any proof that you were not involved with this murder?
I think before all this is over with, we'll have a little proof.
Good morning. Hello, everybody. We are going to be in 2024 today, for the most part. We might do a little bit from 2022. We are going to be doing a deep docket dive into Zachary Adams' petition for post-conviction relief and a new trial. So I've got a ton of stuff we're going to get through here. It's a little bit out of order, but we're going to try to situate it as we go, starting with this petition for writ of error coram nobis. We're going to go over what that is, we're going to go over proposed amendments, and we're going to go down the docket, but not without first thanking Amy E. Thank you so much for gifting 5 memberships, and J Money right behind with the 10. Let's get some love in the chat for Amy and for J Money. Thanks so much, you guys. That is 15 gifts. So you guys are helping support what we're doing here. I'm thrilled to be doing this. I think this case of Zachary Adams is one of the most interesting I've seen, because I think there's a case for actual innocence, and we get a really, really good look, an intimate look at how things are proceeding post-conviction, and then we're rewatching the 2017 trial with all of that in hindsight. So it's just been super interesting. So again, super thanks here to Amy E. and to J Money. We've got a lot to go over, you guys. So first I wanted to talk about this petition for writ of error coram nobis. This was filed in January of 2024 on the 2nd. So that is already the time frame where we're seeing from Doug Bates. This is not the trial attorney. Thought it'd be cool to do this background on the Latin. So coram nobis means before us. And a writ of coram nobis, or a writ of error coram nobis, is a legal order allowing a court to correct its original judgment upon discovery of a fundamental error that did not appear in the records of the original judgment's proceedings, and that would have prevented the judgment from being pronounced. So this is why we're not at the appeals court. We are at the original trial court, and what I think is a huge blessing for a defendant, any defendant in Zachary Adams' shoes, after watching a bit of the 2017 trial, there's a different judge. It's the same court, but the previous judge, Judge Creed McGinley, retired. And Judge Bradbury, who we have seen through these post-conviction hearings, took his seat. So that's why we have a change of judge. It isn't because a different judge would hear this matter or whatever else have you, or because some type of recusal was granted. We are still at the trial court, and we've just got a different judge by what I would say is a very good stroke of luck. So is it still morning? You know, not really. Not really. Although just Shamrock's coming in here saying good morning all. So, you know, existential crisis here. It's whatever time you guys want it to be. So we are going to get into this, really what got the ball rolling. So we are in Hardin County, Tennessee. Comes now the defendant / petitioner. And we've got our first footnote that says counsel's going to refer to Mr. Adams as either the defendant when referring to him at the trial level proceedings, and petitioner in the context of this writ. So we're going to see that used interchangeably. So our background, our history, why we're here. The defendant was indicted on a multi-count, multi-defendant indictment on May 19th, 2015, and went to trial between September 9th, 2017 and September 23rd, 2017. A jury issued a finding of guilt on all counts, and the defendant appealed to the Court of Criminal Appeals after the defendant's motion for new trial and or for judgment of acquittal was denied at a hearing on August 11th, 2020, with an order dated August 20th, 2020. Now, we're going to take a little time travel here. So, when I was reading this and I see indictment May 19th, 2015, they changed his indictment around. They added some charges, and he was in custody for like over a year while they got this right, while they decided how exactly they wanted to indict him. And the reason I know that is because I found this clip from April 30th, 2014, of his arraignment when they added the coercion of a witness charge. So let's flash back. Let's give that a quick watch.
Ronnie Adams.
Yes, sir.
Mr. Adams, in case 14 CR 19, an indictment was returned yesterday that you're charged with coercion of a witness. Do you understand what you have been charged with?
Yes, sir.
Do you understand the nature of that charge?
Yes, sir.
Do you waive the formal reading of the indictment?
I enter a plea of not guilty to the,
Why, yeah, of course, I shouldn't have said that. Plea of not guilty is anything gets passed to the charge coercion of the witness.
yes, Your Honor.
Was he listening, or do I need to repeat?
I'm telling him right now, this is very important.
All right. What this court does, I use scheduling orders. I always put a plea cutoff deadline. Past that point, the court will not accept a negotiated plea agreement.
Now, I recognize that he has a new charge that was just indicted yesterday on coercion of a witness. But at this time, my client has been kept
Now listen to these details here. This is 2014, and I don't know if and when circumstances changed, but listen to what Jennifer Thompson says.
in the Chester County Jail in isolation, and he's not been allowed to even have a pencil and paper in the jail. He's not allowed to make any telephone calls except for one call to me on a maybe a weekly or bi-weekly basis.
Put in these concerns in a motion, and we need to have the Chester County Sheriff here. There are numerous security issues.
Let's take that up on the floor. Court's now adjourned.
Let everybody stay forward.
Everybody take courtroom.
So there is that clip. I thought it was good to tie in because the indictment that they use, the indictment with all the charges that actually end up going to trial for Zachary Adams, that doesn't come down until May 19th, 2015. But on April 30th, when they add this coercion of a witness charge, Jennifer Thompson saying he's in isolation, he doesn't even have a pen and pencil, and I can only speak to him once per day. So I'm imagining if he just picked up this charge, they probably didn't lighten up on his restrictions. How is somebody in that position able to aid in their defense? If they can't even have a pen and pencil, do you think that they were having an easy time looking at their discovery? Do you think they had everything in their cell to be able to look at all the details from all the witness statements and the investigative reports and try to come up with anything? And even though Jennifer Thompson was doing a great job during the pretrial era, trying to get evidence, going down to the discovery room, taking pictures of the evidence, recording what she needed to record, even though she gets in trouble for it, she can only relay information to Zachary Adams on her limited time speaking to him. And we've seen some of her in 2017 arguing and doing cross-examination. Do you think she, with the time factor, and then also her manner of delivery, I'm not sure she's the most efficient person to have delivering information in a finite period of time to somebody that's sitting in a cell and doesn't otherwise have access to the means to put their defense together. So this is the pretrial bubble. That's what we were dealing with before we get to the trial stage. And it's really no wonder to me why we're in this fight now for a new trial with all these issues. So, yeah, and Kay Riggs at the context here says, from what I remember, Zach didn't have much of an idea of what the trial strategy was. I don't think he knew it was in discovery. So I don't think he had a means to prepare, and by being isolated, not having a pen and pencil, definitely think he didn't have the means to properly prepare. So back to this petition. So they acknowledge here that the Court of Criminal Appeals upheld the defendant's conviction on all counts. Oh, and I missed a footnote. So this footnote is about Doug's pro bono representation. So counsel has just been appointed in a pending post-conviction relief petition. He is filing this petition pro bono and will further request the court either allow him to proceed pro bono or just will not request attorney's fees for trial representation in the post-conviction relief case. So we've got the defendant is serving a life sentence without the possibility of parole plus 50 years for his convictions as outlined above for first-degree murder, especially aggravated kidnapping and aggravated rape. The defendant filed a pro se application to this court on July 31st, 2022, alleging both ineffective assistance of counsel and new evidence. Counsel was appointed by this court on the pending post-conviction relief petition based on the ineffective assistance of counsel claim and or new evidence. So here we're going to have Doug lay out the new evidence. And we've obviously had a teaser of this watching some of the post-conviction hearings, but let's see how they laid it out in this 2024 petition. So pursuant to Exhibit 3, defendant's counsel relied upon the work of Dr. Katie Spirko to work on this case in a variety of components that ultimately led to her to discuss two foundationally important items of new evidence that exonerate and exculpate the defendant from any guilt in this case. The first is the proffered testimony of Lisa Sanders, who was an unknown witness who would have testified that on April 13th, 2011, she was taking her children to school and saw a truck driven by a man in black wavy hair, mustache, and wearing camouflage. This is consistent with the composite image that Clint Bobo identified. So longer wavy hair, wearing camouflage, in a truck. Fits the Terry Bobo description. He was a burly man, per Miss Sanders. Per Miss Sanders, he was definitely trying to hide something. While driving, he made a move to conceal whether he had a passenger or not. The vehicle was a tan small truck heading west on Stokes Road in the Benton-Decatur County area. Miss Sanders then later saw the same man on a four-wheeler around her home about 2 or 3 days later. The man had a white box on the back of his four-wheeler. Miss Sanders followed him to Prospect Cemetery, where the four-wheeler was sitting, but the man was not present at the four-wheeler and instead in the woods. Miss Sanders told a friend, Bonnie Ham, who called the information in to the reference hotline. So this gets relayed at some point, somehow, some way. She later saw this man at a grocery store and saw the truck he was in at another house later and has never seen the truck since. Miss Sanders later saw the individual while the case was on TV, and she remembered seeing the eyes and thinking, something ain't right, the day of April 13th, 2011. She confirmed it was Terry Britt. A recording of the statement is provided as Exhibit 1 on the thumb drive. This testimony would have further corroborated FBI agent Art Viveros and TBI agents Terry Dykes' investigation against Terry Britt, and provided perhaps the only eyewitness to the abduction that positively matched Terry Britt to driving with the victim. Further, it would have been evidence contrary to his alibi. This is bolded. This next one is bolded. Further, and importantly, Dr. Spirko met with Jason Autry, in which Mr. Autry recanted his entire testimony at trial. Based upon Exhibit 2A, B1, 2, and C, on an attached thumb drive, Jason Autry made the entire story up to avoid what his attorney told him was a 95% certain of a conviction. It is submitted that both Mr. Autry's testimony and Ms. Sanders was incapable of being procured by defense counsel, and that defendant was without fault. So you have to make the argument that this was unavailable to us to use at the trial. So this allegation is presented in the event the court finds that the defendant was with fault in failing to present both. Some brief highlights from Mr. Autry's testimony. A, he admitted to concocting the entire story in his cell at jail while reviewing the discovery and in discussions with his attorney about the best way to avoid spending the rest of his life in prison. This story was what he presented at trial. He admitted that it was all false, that he used the extensive cell phone data provided in discovery to create a story around it. He said he just recreated his day and added Holly to it. He acknowledged it was all to get him out of jail at the express guidance from his attorney. So we're hearing the express guidance from his attorney. That was something that was, it's a little bit hard to hear at parts. And let me pull the full video of his recanting from the Trial and Error podcast. But you do hear him say things to the effect of, it was his attorney's idea and direction, which is kind of scary. Where was it? Okay. So the Trial and Error podcast, their link is in the description of this video, but in the chat right now, I'm dropping a link to this 51-minute interview where Jason Autry recants. So there you go. And shout out to Sweet Pea, Take It to Trial in the building. Good to see you. Also covering this whole saga with Zachary Adams. Hope you guys are doing well. And I see Meryl's also over here from Take It to Trial's community. Good to see you. We've got, let's see. At one point, he said, quote, "We put it together in 3 days. It is unclear exactly who we were, but it is believed that at the very least, his attorneys were involved in knowingly presenting such a false story." Mr. Autry further explained how details of his story came to light, including parts of the story, how he created the story about the gun from an incident with Terry Britt. Man. Okay, so this is where we're going to argue this court should correct the error that occurred within this court. So, writ of error quorum nobis. Upon a showing by the defendant that the defendant was without fault in failing to present certain evidence at the proper time, a writ of error quorum nobis will lie for subsequently or newly discovered evidence relating to matters which were litigated at the trial if the judge determines that such evidence may have resulted in a different judgment had it been presented at the trial. And my own personal opinion, I'm like a backseat juror. When I first dove into this case, one of the first things I heard was Dylan Adams, probation condition, has to go live with a retired officer. And I didn't know at that point in time that retired officer was also working in the capacity of a private investigator for Karen Bobo. I didn't even know that detail yet. And I was like, red flag, red flag. But then right after that, I learned about the cell phone expert not being qualified, and this ATM video surveillance footage, and then the Jason Autry star witness recanting his statement. And to me, all of those things, new trial. Because even one of those things in isolation, I think casts a significant level of reasonable doubt. So, alone, and then especially in isolation, this stuff that's not available to the defendant at trial, minus the expert witness that they failed to qualify, undermines the confidence in the judgment, in the verdict. So, we've got, let's see. The defendant would show that it is wholly without fault in failing to present the certain evidence above at the proper time. Specifically, as it relates to Jason Autry's testimony, consider the following. On March 1st, 2017, Jennifer Thompson, defendant's counsel, was accused of being unethical for merely trying to record the hearsay statements of Jason Autry before trial that were introduced through her attorney, Michael Scholl. Ms. Thompson then requested the ability to meet with Mr. Autry directly and was unable to. So attempts were made, and this was just wholly unavailable to the defense at the time of trial. So both Mr. Autry and Mr. Adams have been incarcerated ever since they were indicted, and thus they had no opportunity to discuss this case. In truth, the decision to wholly and completely recant his testimony has rested fully with Mr. Jason Autry. He chose to in late December of 2023, and the defendant is without fault in just realizing this. Further, the defendant and his counsel were without fault in failing to find Lisa Sanders and her very helpful testimony that shifted guilt to Mr. Terry Britt. And it's Britt with 2 T's. What's interesting here is apparently Bonnie Ham relayed this information to the tip line. So was the tip line so overwhelmed that they never, even when they entered everything into the database, never got to look at it? Or was it a tip that never got entered into the database? Or did Bonnie Ham not actually make this call? So, insofar as whether Mr. Autry's testimony being revealed as perjury, consider the following. At the conclusion of Jason Autry's testimony, the trial court implied that the parties might want to re-enter plea negotiations. The implication was that the defendant was going to be found guilty because of Mr. Autry's testimony, parentheses, which the record will bear out was perjury. B, the court said Mr. Autry's testimony was some of the most credible and persuasive testimony the court has ever seen. We watched that clip yesterday. It's a standalone clip. If you go to the videos tab on this section, you can watch that hearing, parts of that hearing in a clip. It is not surprising because Mr. Autry has clarified he concocted the story over months and months of examining the discovery, and as he said, he already had a story of what they did that day. He just added Holly to it. Further, Mr. Autry said he was very well trained by ADA Jennifer Nichols, whom he referred to as the, quote, boss of it all. Most importantly, at Jason Autry's plea deal, Assistant District Attorney General Paul Hagerman said that Mr. Autry's testimony, and this is the same hearing that's clipped if you want to go watch it, answered many questions that were left open factually in the investigation, and many questions Karen and Dana had with what happened to their daughter, and it was a very important piece of getting justice for Holly. That's the end of the quote. This is, respectfully to the district attorney's office, staggering in that it indicated all 4 defendants with, quote, many questions left open. And that it indicted all 4 defendants. So they didn't have, until Jason Autry testified, they didn't have answers to these major questions about what happened. Yet they had 4 people sitting indicted for years. Putting that issue aside, no greater corroboration of the importance this testimony had on the result than the DA and court's comments on it. So, right there, you can, Judge Bradbury, we're arguing to you, this was unavailable to us, and you can't just say that it's insignificant. That we weren't able to tell the jury, hey, Jason Autry said he made it all up and concocted his whole story by sitting with his discovery folders and studying it to put the details together, to weave together a compelling story. Because you have commentary from the DA and from the judge saying it was extremely compelling. During this plea deal, the court stated that Mr. Autry's counsel told him, we will not need a trial date, though it clarified defense counsel did not say anything was worked out. This is difficult to I think there's a typo. This is difficult to reconcile with how quickly the court wanted to press the case forward. Incidentally, during the same hearing, the trial court said if it was involved in the case, it would be a race to the district general's office. And this link didn't work. So I went and found a different upload because this one ran into a dead end and I really wanted to see it. And that's what we looked at yesterday. But it was interesting that at the time of writing this video must have been available. And now when I checked on what would have been November 29th, 2025, the video is no longer up. So I don't know what channel it was from or why it got taken down, but just interesting. So, and yeah, that race for a judge to say, I'd be running to take a plea deal. I think Jason Autry is a smart one. Not very good for a judge to be saying that. Taken as a whole, it cannot credibly be argued otherwise that the same district attorney's office that said Mr. Autry's testimony answered, quote, a lot of questions that were left open factually, cannot be left now with those same unanswered questions without his testimony. The issue is not whether a different trial result will occur, it most undoubtedly will, but whether the state can even present the case. So, food for thought, you guys. State didn't want to put Dylan Adams on the stand. They did not want to play that interview where it's really Jackson leading all the details in his questions and just getting one-word responses from Dylan for a huge chunk of the interview after he lived with Dennis Benjamin. State didn't want to put Dylan up there. State doesn't even want Dylan's stuff to be part of the record in these proceedings. So at some point, the tides turn. They move on from looking at Dylan Adams as being their key to getting a conviction in this case, and they go to Jason Autry. Jason Autry becomes their star witness. He's like, yeah, I can tie that rusty revolver you found. I can tie all the pieces together. Well, what are they going to do now if they have to present the case again? Are they going to try to rely on Jason Autry to repeat his story? I mean, maybe he has enough time to rehearse now. We heard his slip up when he said he didn't have enough time to rehearse during his testimony at the 2017 trial. A very interesting slip of words. What are they going to do? What are they going to do? And is it going to be so easy for the state to impanel a jury that just is out to pitchfork and get justice for whoever's sitting in front of them for this case? Or are they going to be a little bit more savvy, a little bit less inflamed and impassioned? And I'm not trying to judge anybody for being impassioned and thinking they're doing the right thing. I just think it's important to acknowledge that human nature, we feel very impassioned and emboldened, and it can lead to us getting to the wrong end, even if we mean well. So, yep. Gwen and Garnett, no Dylan, no Autry, no evidence. I mean, what would we do with the rape charge without either of them? What evidence? I think we have a sufficiency problem. What would there be to support bringing that charge to trial and presenting that charge to a jury? So, a lot of questions. The petition goes on. The defendant submits that constitutional due process requires the tolling of a limitations period when a petitioner would otherwise be denied an opportunity for the presentation of claims at a meaningful time and in a meaningful manner. And this is Waldarts? I don't know how to say that, v. State. Overturned as it relates to whether plea guilty defendants are entitled to the writ by subsequent Tennessee Supreme Court case of Frazier v. State. So wherefore, premises considered, defendant prays upon this court. So what relief do we want? 1, for the court to grant this writ of error quorum nobis and set aside the defendant's every conviction in the above style cause of action. 2, for the court to work with counsel for defense and the state on scheduling this matter within a reasonable time frame in light of the voluminous record and transcript the court must read. 3, for the court to allow the defendant to use the subpoena powers of this court prior to the hearing in this matter. 4, for the court to allow all prosecutors involved to stand for cross-examination and to be compelled to produce requested documents under the subpoena powers of this court. And then 5, for such further and general relief to which the defendant is entitled. And then we have the signature here. I, Zachary Adams, I think there's a typo in his name, hereby swear and affirm under threat of penalty of perjury that the information submitted above is true to the best belief and information I have available as indicated or upon my factual knowledge and belief of the same, with his signature here on January 19th, 2024. And we've already seen, obviously 1 is the major decision, right? We still have the December hearings. It doesn't seem like the judge wants the state to need the January hearing dates, but they're available if there's spillover, if they need more time. Big decision for the judge to make. So this has not been made yet, but they did get a calendar schedule. They had the, 4 or 5 series of dates throughout 2025 and maybe 2026 with those January dates to get this matter heard. They have gotten judicial subpoenas, so they've been granted this relief in part. They've been able to call prosecutors to the stand and examine them. So they've gotten this relief. And I think they've gotten relief in some other ways as well. So far, this has already been a successful petition. So there's that, you guys. That was the very initial petition for writ of error quorum nobis. We're going to next get into an amended petition for post-conviction relief that was filed at the same time. Where I think this is where we get some ineffective assistance of counsel stuff laid out. But before we do that, holy moly, I see the chat turning green. If you are not looking at your screen, you might have just gotten a membership very kindly gifted here by FFS. It's a great opportunity to put FFS in the chat because we're saying a name, we're not cursing. So shout out to FFS. Much love. That is super, super generous. Let me update this banner before we get into the next document. Let's see. We have, holy moly, that's 35 new gifted memberships. Thanks to Amy E, J Money, and FFS. Thank you so much, you guys. Big thank you. And thanks for hanging out too. You know, this is a Sunday, so it's cool that you guys are spending your time here. We're here reading documents, which if you ask me when I was back in school, if this is what I would imagine I'd be doing when I'm well out of school, well graduated, no more homework, am I going to sit here reading documents on weekends? Never would have pictured it, but here we are, and I love it. Let's see. All right, scrolling back a little bit. Everybody saying hey to each other. We've got GV saying that Kathy Rason, shout out to Kathy, said on Law and Crime Chat before you started covering this, the state is fighting so hard because they don't have a case if there's a new trial. That's what it looks like. I mean, there's also, I would assume, an unavailability of some witnesses. I mean, they called a lot of witnesses in the first trial. Not all of them were spring chickens. So there's that part. And we also heard, like Jason Kilzer, for example, we've learned that he's no longer alive. He was killed in a law enforcement officer involved shooting this August 2025. So he's unavailable if he's needed for anything. And then even those that are still available would willing to show up. I mean, memory gets worse and worse over time. You're just going to run into this issue where the only thing they remember is the detail that they memorialize in a statement that they gave and can refresh their memory with. So, and then they've got to keep, I mean, some witnesses only went up there and said, hey, I mowed the lawn that morning. But other witnesses, they're going to have to keep track of what they said at trial 1, namely Jason Autry and Rebecca Earp. I think gave lengthy testimony. Terry Britt, who didn't really answer all that much, but he was insistent about the bathtub. So he's got to keep the bathtub story straight. Who else do we got? Dinsmore. Dinsmore's got to keep his testimony straight. So we did stream yesterday. Yesterday was a trial watch. We looked at Terry Britt, and then as a bonus, we looked at some a little compilation I put together about how important Jason Autry's testimony was, and then put it side by side with his recanting. So, yeah, and Meryl says, Jason, another one that lied so much, and now he's not around to testify again. So I think he had concerns at the first trial already. If you listen to his testimony in 2017, he was concerned about exposure, but put some faith in what he was being told. Present day, I think he's so worried about exposure that he wouldn't want to take the stand at all. You know, a bit of a different question than would he take the stand and be able to tell the same story. I think he might get up there and just plead the fifth until they have to take him off the stand. So, and I can picture that happening. So I can also picture him trying to get up there and tell the same story. And maybe he can do it, but he'd be facing different counsel and cross-examination. So, and out of curiosity, I would love to see it. I would love to see it. Let's see, we've got... And yeah, KLB, it's out of order. So if you go back and watch yesterday's stream, and it was shorter, it's a nice chance for everyone to get caught up. We're going to continue with the trial watch tomorrow. So tomorrow we'll be finishing day 7. Terry Britt was the only witness we watched from day 7. We've got to get through the rest of day 7. But I think it was a shorter day anyway. So, and maybe we'll start day 8, who knows. But we'll be back to trial watching tomorrow until we get through the rest of the trial. And then, I don't know, we'll keep going through these documents, all this old stuff. It's really insightful to see. So, GV says, I want to know if the state has given a specific reason as to why Jason Autry is too dangerous to transport. It's their words. All kinds of dangerous people are transported to court all the time. They just didn't want him to be called for the post-conviction relief hearings. It was another argument against anything relating to Jason Autry being on the record for consideration for the purpose of this petition for post-conviction relief on new trial. So, and remember, since he didn't actually get on the stand during these proceedings, the judge did grant the state's motion in limine to exclude, for the purpose of this proceeding, not from a new trial, that recanting statement. So, yeah. Kay Rigg says, I always make my wife call out of work because we need to replace our tub that has been leaking for weeks, even though after buying it, I don't plan to install it for another 3 weeks. And she works at a news station, And it's arguably probably the busiest day in the news cycle that Darden, Tennessee has seen. So, great day to leave your job. Just crazy. Just crazy. True crime fraud, it says the state is so maniacal they'd probably pull Jason's immunity and then say he do it. I can picture them trying to get creative. You never know. Shella, I'm not exactly sure where Zach is being held until the next hearing. But the next hearing, just FYI, you guys, if you've missed it, is December 29th and 30th. And the judge is like, I'd be down to get together on New Year's Eve, the 31st, if we can get this thing going. But the parties did not seem to want to commit to that at that point in time. So, let's get back into it, you guys. The next thing we're going to look at is the petitioner/defendant. Remember, they're using both terms. Amended petition for post-conviction relief. I think the procedure is going to be repetitious. This was filed at the same time as the writ of error quorum nobis that we looked at. They're laying out the timeline. That this amended petition was due today. That's why they're rushing to get it in. And he's filing this contemporaneously, and this is really tiny, with this amended post-conviction relief petition, a writ of error quorum nobis that we just looked at, and counsel submits that both issues are substantially related. Let me move over here. So petitioner incorporates all statements of facts in the original petition, except as indicated below. So paragraph 17 is amended to reflect that there is also a writ of quorum nobis filed in this court and presently pending as it is filed on the same date. And paragraph 19, undersigned counsel is appointed to represent the defendant in the underlying proceeding. Defendant further amends paragraph 16 to expound upon and add to the petition as set forth below. So this is where we're going to expound on the ineffective assistance of counsel arguments. So one, they're incorporating this against all counsel. So counsel incorporates each and every allegation in the original petition against all counsel who represented the defendant, specifically James or Jim Simmons, Jennifer Thompson, and Jerry Gonzalez, as they are jointly and severably liable for their failures to provide adequate and effective assistance of counsel to the defendant. Now, I think an important part of this is this was a good vehicle for them to be able to argue to the court, we need to hear them testify. It supports our argument for ineffective assistance of counsel. And I would imagine if they didn't incorporate this against Jerry, the state would have been like, well, there's no reason to call Jerry on the stand. He's just going to tell you about how the judge is watching football. Who needs to hear that? So, specifically, James or Jim Simmons on March 1st, 2017, failed to argue to the court that Ms. Thompson was allowed to record conversations between either attorneys, the court, or really anyone else it wanted to in defense of the case. So Jim didn't stick up for her co-counsel. He stepped away. We heard testimony from Jennifer Thompson that in this, I think it was in chambers, he steps aside and says, Your Honor, I think Jennifer might need counsel. So there's a footnote here. A copy of the March 1st, 2017 transcript will be provided to the court at a motion to introduce trial transcript before the hearing and or evidentiary hearing in this case. So instead of asking any of the outraged attorney Michael Scholl for the authority upon which he wailed was unethical and asking the court to consider his statements as admissible hearsay under Rule 803 1.2. And generally, Simmons v. O'Charlie's, is that the steakhouse? Tennessee Court of Appeals, and why they could not be recorded. His comments made a tacit implication that Mrs. Thompson had done wrong. As can be seen below, this was not merely a trivial. There's a lot of typos in this. As can be seen below, this was not merely a trivial, as it set the stage that somehow Jennifer Thompson was the problem. Mr. Simmons further reinforced this belief to the trial judge that Ms. Thompson was the problem in his ex parte motion to withdraw, that he positioned to the court that Ms. Thompson's belief that Mr. Adams was innocent was somehow misguided. Oh, that's noisy. I want to withdraw because my co-counsel and I disagree on our client's innocence. That's noisy. For the further reasons set forth below, the record will ultimately acquit Mr. Adams based upon Mr. Jason Autry's complete and total recantation of this testimony at trial that we now realize was completely perjured testimony. Further, Mr. Autry's truthful testimony provides the necessary alibi for Mr. Adams. But Mr. Simmons cast the die to the court that Ms. Thompson was the problem, not the forthcoming introduction of perjured testimony that was about to taint irreparably the trial. Next, failure to find, develop, and otherwise introduce exculpatory evidence and/or new evidence. Defense counsel failed to find, develop, and otherwise introduce the following exculpatory evidence. A, there was substantial exculpatory evidence that one or more defendants were at an ATM/Sonic and gas store on April 13th, 2017. 2017? 2011. 2011. We might have to start going through this with a little pen, because there's a lot. There's a lot. This was pled in the original post-conviction proceeding. Petition. B, that Mr. Zach Adams was on his grandmother's computer during the operative time frame on April 13th, 2011, not 2017. This was pled in the original post-conviction petition. In a separate petition for a writ of quorum nobis, another typo. Oh no, we're just going to have to circle everything. It is alleged that the defendant's trial was significantly prejudiced by two issues that the defendant was without fault in presenting this to the court. To the extent the court finds that the defendant was responsible for presenting this testimony, then the defendant alleges it was because of ineffective assistance of counsel. Specifically, so here's some stuff. This is Doug Bates. So, and this was the deadline. He submitted this on the deadline. And he's doing it for free for what it's worth. Defense counsel failed to present Lisa Sanders as a witness who would have testified that on April 13th, 2011, she was taking children to school and saw a truck driven by a man in black wavy hair, mustache, and wearing camouflage. He was a burly man, per Ms. Sanders. Per Ms. Sanders, he was definitely trying to hide something. While driving, he made a move to conceal whether he had a passenger or not. The vehicle was a tan small truck heading west on Stokes Road in the Benton, Decatur County area. So this is what we read in the other thing. Miss Sanders, then later saw the same man on a four-wheeler around her home about 2 to 3 days later. The man had a white box on the back of his four-wheeler. Miss Sanders followed him to Prospect Cemetery, where the four-wheeler was sitting, but the man was not present at the four-wheeler and instead in the woods. Miss Sanders told a friend, Bonnie Ham, who called the information in to the reference hotline. She later saw this man at a grocery store and saw the truck he was in at another house later and has never seen the truck since. Miss Sanders later saw the individual while the case was on TV and remembered seeing the eyes and thinking, something ain't right, the day of April 13th, 2011. She confirmed it was Terry Britt. Copy of the statement is provided as Exhibit 1 on a thumb drive. So, yeah. So, Stokes Road is near where Holly's remains are found. So, I'm assuming that's near the cemetery. Peter, so can Dr. Spirko, Katie Spirko, I'm assuming, be a witness for Adams at the hearings in December? So the defense has rested their side of this petition argument. So it's going to be the state presenting. And I don't think the state wants to call Katie, but maybe they will, to be like, and you're doing something sneaky, aren't you? I don't know. I don't imagine the state wanting to call her, but I imagine the state having issue with her either way. Maybe they'd be bold to put her on the stand and yell at her or something. So, are you aware that 12 jurors? I can kind of hear it. All right, so the cemetery's on the other side of I-40. Cool beans. Yeah, I'm still learning the geography. I have a decent visual of the, the main roads to me of the map that they keep showing. Like, the main roads kind of do, this weird sort of, rhombus-y triangle shape. And, of course, there's all, the little routes in between the smaller roads. but that's like my limited understanding of the geography so far. But I'm picking it up. I'm starting to pick it up. All right, we've got next. It is alleged further. Defense counsel failed to pierce through Jason Autry's testimony to reveal it as the perjury that it was. Based upon Exhibit 2A, B1, 2, and C. On an attached thumb drive, Jason Autry made the entire story up to avoid what his attorney told him was a 95% certain of a conviction. Again, it is argued that both Mr. Autry's testimony and Ms. Sanders was incapable of being procured by defense counsel, and the defendant was without fault. This allegation is presented in the event the court finds the defendant was with fault in failing to present both. The defense counsel should have requested a mental health testifying expert, this is the next argument, to help explore the ways in which Shane Austin, Rebecca Earp, Dylan Adams, this DTB is circled here. I think that's just a signature of Doug Bates to say that he's the one that wrote this note in. Other witnesses for the state, and Doug and Zach initialing here, and or Jason Autry succumbed to manipulation, coercion, pressure, or otherwise manipulated and or unstable mental health to provide the false statements that they did throughout the proceedings. Further, a neuropsychologist with memory expertise should have been retained to test the validity and indicators of accurate recall to rebut Jason Autry's testimony. 18. The defense counsel should have requested a handwriting expert or otherwise lay testimony to show the statements of Dylan Adams was not Dylan's. Oh, we heard a little bit about that. So remember, we have like some letter that Dylan, he gets on the stand and says he doesn't write that. He doesn't even spell that good. Doesn't recognize the handwriting. And it's written, it's like some thank you love letter to Dennis Benjamin and his wife. About like, oh, thank you so much. You guys are the best. And here we go. The statements of Dylan Adams was not Dylan's and therefore fraudulently obtained. There was also a different one, a TBI. It was written as a report, but it was in first person language as if it was Dylan writing, like I observed, but it was in Dylan's point of view, even though it was written by a TBI investigator. So there was more than one documented issue. So crazy, crazy, crazy. Oh yeah, and that he wants to come back and live with them, please. Yeah, okay. Just crazy. I mean, just common sense says no. I mean, that kind of sounds like, even if it were true, sounds like Stockholm Syndrome. Upon information and belief, the landowner on whose land the victim's remains were found was not called to testify to submit into evidence that prior to the finding of the remains, there were multiple efforts to find the remains on the property. Oh, what? Further, the property was a known place where other people, including some or all of the defendants, had used drugs before, and it was known to be that. The point should have been argued that it was reasonably possible that the remains were placed there by some biased person and or organization in an effort to remove guilt on others and or frame the charged defendants. Uh-oh. Uh-oh. Further, along this point in paragraph 19, what we just read, an expert should have been retained to explore why no soil samples were taken from the location the skull and remains of the victim were found, and how the remains of the victim could have been in the position they were in if they had been there for so long as the state alleged. 21. Defense counsel should have issued a subpoena to Natalie Bobo. Yes. Holy moly, yes. Holy moly, yes. To rebut the testimony of Jason Autry and further introduce Exhibit 3, a text from Holly Bobo to Natalie Bobo to present the theory that the disappearances were related. Oh, so this is a bit without context. I want to know more about that. Defense counsel should have rebutted Mr. Autry's perjured testimony with evidence as follows. So this is what we wish we saw on cross of Jason Autry. This is Doug Bates writing this. Failure to provide evidence to the contrary that the alleged gunshot would have echoed the way in which Jason Autry lied the way that it did. And yes, I still have trial and error open. Okay. Trial and error. They went out and they tested this. Go check that out. They go and do the example firing. And yeah, it's not the boom, 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 boom. Or maybe in the words of Relly.
Boom, 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 whatever.
So yeah, they don't confront that. They don't confront those details. Failure to provide a photo that showed you can see below the interstate by the Tennessee River. Mr. Autry lied about where he and Mr. Adams were when Mr. Allegedly, maybe Mr. Allegedly, Mr. Adams allegedly shot the victim. Further, defense counsel failed to review flood records and or water levels from the day in question to see even if Mr. Autry's story was possible with the water levels from that day. Because remember, it was like beachy, so if the water levels were higher, that part of land that they were talking about with this rock, they wouldn't even have been able to like stand there and take the blanket and the body that he didn't know was Holly, according to his testimony, out and lay it on the ground. So defense counsel should have issued a subpoena to Michael's school. I think that's Scholl, and or Mr. Robert Paris. Yeah, that's the attorneys. For all communications they had with the prosecutors in this case regarding Mr. Autry's testimony. Oh! Do you guys remember Derek Wright and Adrian Love and those emails from the YSL trial when they had attorney Derek Wright get on the stand to talk about his correspondence with prosecutors about Mungtung's plea? That's I would have loved to see that in this case, because that was a time over in the YSL case. All right, 2, ineffective assistance of counsel at trial. Defense counsel failed to provide effective assistance of counsel at trial by the following. A, ineffective, unclear, not persuasive, unorganized, and generally both lackadaisical and rambling in presentation, the cross-examination of key witnesses. I agree. Failure to cross-examine Brent Booth on his statements that Karen and Dana Bobo lied throughout the investigation. And we haven't watched... Did we watch Brent Booth? We did watch Brent Booth already. That was kind of short. So we didn't get that. Jury never gets to hear that. Failure to cross-examine Mr. Ernest Stone about all particularities of the day he found the skull in question, including any criminal record of his and or his dealings with the sheriff's office before the day he said he found the skull. What? The day before he finds the skull, there's something sus going on? Uh-oh. Failure to call Matt Stowe as a witness and introduce into evidence why he recused his office from the case. We've got failure to argue that the vehicle that it was alleged that Zach Adams and Shane Austin were driving was too small for the victim to be in the same vehicle. Failure to push Jason Autry about the idea that he'd found another body there and never reported it, and otherwise follow up on this clearly exaggerated and perjured testimony. And Katie Spirko asks him about that in the interview where he recants. So, failure to ask Mr. Autry why has not pled to anything and instead is still saying he is not guilty to the charges. Because remember, at that point, he didn't successfully have a disposition in the case. Further, defense counsel should have asked if Mr. Autry had been charged with attempted murder of Dylan Adams. Oh, yeah. The defendant incorporates, because remember, he testifies. He's like, well, I changed my mind. I go out there, but there's like a guy on a boat, and I just decided to change my mind. So we just kept fishing, me and Dylan. Like the Friday after this all happens or something. He was supposed to go kill whatever. But it got foiled. Were you ever charged for that? Like, if the state believes you, then you would think that they would think, hey, you tried to kill somebody. You made attempts to take someone's life. The defendant incorporates the entire affidavit of Terry Dykes it attached to the motion for new trial to show that on its face that any jury would believe Mr. Autry that any jury would believe Mr. Autry was because of ineffective cross-examination and defense evidence being submitted into trial. And we have a note written in that further, defendant asserts counsel did not properly and effectively utilize Arthur Viveros and Terry Dykus at the trial, and prove further Terry Britt committed these crimes. We have an emoji for that. We have the I did these crimes emojis. So if you got a gifted membership today, or if you've been a member, thank you for your support. Amy E, J Money, FFS helped bring in 35 new members. You guys can use the I did these crimes emojis that we have because of Woody, star witness in the YSL trial. So we've also got a super sticker here from Derek Cresson. Thanks so much, Derek, for all your support. Like every stream, I get a cool sticker from Derek. Let's get him in the sponsorship window. All right, banner is updated. Yeah, the I did these crimes. K-Riggs is on it. Oh, man. So we've got a lot of underlining in this next point. So failure to present this simple dichotomy of the proof to the jury. Mr. Autry said Zach Adams and Shane Austin were there to teach Clint Bobo how to make methamphetamine. That means for years, Clint Bobo obstructed justice and lied repeatedly about the day his sister was kidnapped. Or you can believe Clint Bobo and his story, and thus Mr. Autry is lying. It cannot be reconciled either one way. That is a great point, and I like that they say it's a simple dichotomy. Because this, you can get kind of lost in the weeds with some of this stuff. But this, Autry, how are you there making meth with Clint Bobo if Clint Bobo has no idea who you guys are? And I don't think the trial strategy would be to make Clint Bobo and like be aggressive and start badgering him on the stand. But you ask Mr. Autry these things. Well, Clint didn't give any indication he knows you. How do you know? And just press and press and press away. Because how can you reconcile this? Significantly, failure to allow Mr. Zach Adams to testify. Ms. Thompson stated in a subsequent interview that Zach really wanted to testify. Ms. Thompson coerced Mr. Adams into not testifying and thus denied his effective constitutional right to testify himself. Next, we have miscellaneous issues that arise to ineffective assistance of counsel. So upon information and belief, the defense counsel failed to ask for either the court to disqualify itself and or the court officer, Anthony Alexander, who upon information and belief is first cousins to Dana Bobo and business partners with ABC Cleanup Together, to disqualify him from the proceedings. Upon information and belief, Mr. Alexander had direct engagement with the jury. And yesterday, the clip I keep referencing that we watched yesterday from the court, we see the judge walking before the court goes on the record. Judge is out and about in the gallery and spends, I don't know, like about a minute, speaking with Dana and Karen Bobo in the gallery. While the case is still open, you know, you really, I don't watch trials where I see the judge walking around the gallery. But in this case, right before Jason Autry took his plea and the judge said he didn't know that that's what was about to happen, he's out there chatting it up with the victim's family out in the gallery. So yeah, EJF's a small town's gonna small town. Yeah, I don't know. Yes, next hearing is December 29th. Hey, Andrea, good to see ya. We are just going through the first petition filings from January of 2024. It's hard to keep the years straight. It is hard to keep the years straight. Yeah, so let's keep an eye open for this, guys. We have, when we start doing the trial watch tomorrow and Tuesday, it might go into Wednesday with closings. But of course, we'll be able to go right to sentencing and the verdict being read because there's no deliberations. This is 2017. But K-Rake says that after the verdict is read, the judge chops it up with the jury and makes it clear he knows several of them very well. So, yeah, not good. Not good. Because there's already a concern that, if judges say something and give an indication to the jury that they lean one way or another, just because they're a judge, the concern would be that jurors would put weight into what they see the judge sitting on the bench giving the impression of. But especially if you know them, now that risk of undue trust and giving undue weight to something that a judge may or may not should be indicating is even more serious. So, uh-oh. So, that's a lot. That is a lot. Let's see. Okay, we were on 26. So Ms. Thompson should have better observed the landscape of this case and realized that the court had very little confidence and trust in her capabilities as a trial lawyer. She was attacked by opposing counsel and fellow defense attorneys and lost confidence in herself and in her case, resulting in a significantly flawed presentation of evidence in opening and closing statements. She needed to either withdraw or ally herself with a competent attorney who had some working relationship with the trial court and/or prosecution. The move to try and bring Luke Evans in was a disastrous move in which she lost the confidence, if any remained, of the trial court. And now we're going to discuss effect. So, defendant submits that either each complaint on its face and/or all of the grievances combined and taken in total were below the reasonable standard of competency and/or the constitutionally provided safeguard of effective assistance of counsel, pursuant to Article 1, Section 9 of the Tennessee Constitution. Further, the ineffective assistance of counsel prejudiced the defendant. It is submitted that he would have received a different result at trial. Specifically, defendant presents the following. At the conclusion of Jason Autry's testimony, the trial court implied that the parties might want to re-enter plea negotiations. The implication was that the defendant was going to be found guilty because of Mr. Autry's testimony, which the record will bear out was perjury. So we're repeating what we saw in the Coram Nobis petition. The court said Mr. Autry's testimony was some of the most credible and persuasive testimony the court has ever seen. It is not surprising because Mr. Autry has clarified he concocted the story over months and months of examining the discovery. And as he said, he already had a story of what they did that day. He just added Holly to it. Further, Mr. Autry said he was very well trained by ADA Jennifer Nichols, whom he referred to as the boss of it all. And then we get this same thing, Paul Hagerman saying Autry's testimony answered many questions that were left open factually in the investigation, and many questions Karen and Dana had with what happened to their daughter, and it was a very important piece of getting justice for Holly. This is, respectfully to the district attorney's office, staggering in that it indicted all 4 defendants with many questions left open. Putting that issue aside, no greater corroboration of the importance this testimony had on the result than the DA and court's comments on it. Again, same thing, the same plea hearing. And honestly, we looked at it yesterday, but I have that clip portioned. We can just run it back so you can see and hear it in the judge and the DA's own words. Where was it? All right, so this is the clip where he's going and speaking with the Bobo family. It's silenced out, but this is before he's aware that Jason's here to take a plea. It goes on, there's like 10 more seconds. And it's muted, there's no court sound.
I was informed
This is the commentary.
by defense counsel fairly early on, and they didn't tell me something had been worked out. They just said, we will not be needing a trial date. And I had said prior to that, we were still in Decatur County. That's why I looked back and saw Miss Nichols, and you guys were both there. You guys, as well as all the other attorneys, were there. And I think you probably remember me saying, if I was involved in this case from a defense standpoint, it would be a race to 201 Poplar. You remember me saying that? And apparently you folks won the race. Then sometime after that, the attorneys got together with the prosecutors. There was a proffer in this case. Actually, Mr. Autry met with attorneys and prosecutors and went through the route of what he testified to at the trial. Is that correct?
Yes, sir.
So we're ready to proceed now. You want to announce the basic terms of this plea agreement?
Yes, Your Honor. Are we far enough away?
You are, I don't know about him.
I can talk through it. I can sort of.
I can hear you.
Yes,
Make sure the court reporters can hear you.
It's a little hard.
All right. I'll talk as loud as I can. Actually, 3 years ago to this day, Mr. Autry testified in this courtroom and told the jury and I guess the world, as it were, what happened April 13th of 2011. In this courtroom then and in this courtroom today, Karen Bobo, Dana Bobo, they're here. And they are in support and agreement with this guilty plea, which takes into account the realities of the prosecution before Mr. Autry cooperated, and then takes into account the importance of his cooperation and his credible, truthful testimony at trial.
I addressed earlier at the motion for new trial on the co-defendant. His testimony was some of the most credible, persuasive testimony I've ever heard given in a courtroom.
And it answered many questions that were left open factually in the investigation. It answered many questions that Karen and Dana had about what happened to their daughter, and it was a very important piece in getting justice for Holly. This guilty plea is to 17 CR 10.
There you go. That's in their own words from the proceeding that's being referenced in these petitions. And again, this recording didn't work anymore. I couldn't get to this link. Next, they have new evidence. They're going to address a little bit more on that. So counsel incorporates all statements above and state that the new evidence, I can move myself. New evidence referenced above are substantial grounds to justify post-conviction relief in the alternative that this writ of error coram nobis is denied, and this is the vehicle upon which a new trial should be granted. Wherefore, premises considered, defendant/petitioner prays upon this court to, and we saw the relief earlier, but set aside the convictions, work to schedule this matter within a reasonable time frame, allow the petitioner to use the subpoena powers of the court, for the court to allow the prosecutors to be cross-examined, to be called as witnesses, for the court to approve all, that's new, for the court to approve all discretionary fees for Mr. Adams, who's indigent, and for such further and general relief to which petitioner is entitled. So there we go. All right, back over here. We've got some motions to put things under seal. It was a joint motion for a temporary order, and it was agreed upon. And then, let's see. Then we have on April 5th, a motion to strike exhibits. So this is the state. The state, outside of this temporary order, it's motion to strike exhibits or in the alternative place exhibits under seal. So this is quite long. Let's see. State of Tennessee wants to strike Exhibit 1 and 2 of Petitioner Zachary Wright Adams' writ of error coram nobis. This is all the background. The petition for writ of error coram nobis and amended petitioner for post-conviction reference and rely upon 3 exhibits contained on a USB flash drive and filed with the Hardin County Criminal Court Clerk's Office. The contents are as followed. So they want to get rid of this unsworn video recording of a statement from Lisa Sanders, and this unsworn video recording of a statement from Jason Autry. And then C, there's a paragraph here. Exhibit 3 is the affidavit of Katie Spirko, a psychologist acting in the role of investigator, retained by petitioner's counsel at the time the 2 requests for post-conviction relief were filed. Upon recent representations made by Petitioner Adams' Counsel of Records, as of February 3rd, 2024, Katie Spirko is no longer employed by Petitioner Adams' Counsel. So then they go to argument. Exhibit 1 and 2, the unsworn video recordings, are not in the form of a notarized affidavit. Exhibit 3, the affidavit, contains inadmissible hearsay, and none of the three should be considered by this court unless properly authenticated and admitted pursuant to the Tennessee Rules of Evidence. On January 31st, 2024, counsel for the state and for Petitioner Adams filed a joint motion for temporary order, placing the exhibits attached to the writ of coram nobis and amended post-conviction relief under seal. Lisa, if you missed it, she says that she saw a man with a mustache and a burly appearance driving in like this tan beige truck, and that it appeared when he was driving by her where she was waiting to take her kids to the school bus, he made a motion as if to hide somebody that was in the passenger area of the car. She later sees that same individual on a four-wheeler near a cemetery, and then also at a grocery store with the same truck. When she sees the news reports about Holly Bobo, she says it was the same person that was being shown and that it was Terry Britt on the screen, because initially they were looking into Terry Britt, and she says it was Terry Britt. She knows now it was Terry Britt. She also said that she had told her friend, Miss Ham, that, hey, this weird thing happened, and that Ham called it into the tip line. So that's the backstory on Lisa. It was summarized in the petitions we read earlier. And I'd like to hear a little bit more. Maybe we'll get more in the response to this issue. So their argument, they're saying that a witness statement must be in the form of an affidavit, which 1 and 2 were not. Let's see. It has to be pled with specificity. Let's get to the specific issues. Okay, so they say it should be noted, and same will be addressed in state's motion to dismiss the writ, that Exhibit 2, the unsworn video recorded statement of Jason Autry, is not newly discovered evidence. Mr. Autry's credibility was at issue the moment he swore to tell the truth and take the witness stand during Petitioner Adams' trial. In fact, there was significant direct and cross-examination of Mr. Autry, singularly devoted to his credibility, during Petitioner Adams' trial. The fact that he recently recanted, calling into question his trial testimony, goes directly to his credibility at trial, which was already thoroughly weighed and considered. I hate this argument because how are you weighing it against anything if the jury didn't have this available to them? What were they weighing it against? They were weighing it in isolation without this new testimonial evidence, out-of-court statement. So, let's see. They're arguing that the court must also find that this evidence may have resulted in a different judgment had it been presented. All right. Now they're going to argue about Lisa's statement. So the statement provided by Lisa Carroll in Exhibit 1 does not meet the Nunley standard for witness statements attached to a petition for a writ of error coram nobis. According to the standard, to warrant an evidentiary hearing, the witness introducing newly discovered evidence must submit an affidavit explaining the significance of the evidence and confirming that it was not disclosed to Petitioner Adams or his attorney prior to trial. The unsworn, unnotarized statement provided by Lisa Carroll in Exhibit 1 falls short of the standard. It lacks the necessary formality of a notarized affidavit as required by Nunley, is inadmissible hearsay, and should not be considered. They're going to say the same thing about Jason Autry. This is a long footnote. Oh boy. Let's see. Exhibit 2 is a video interview of Jason Wayne Autry, created on December 22nd, 2023, at FCI Memphis, where Jason Autry is incarcerated, awaiting sentencing on federal firearms charges pending in the U.S. District Court, Western District of Tennessee. During this video interview, Jason Autry makes unsworn statements recanting his trial testimony in the Holly Bobo case. It's important to note that on October 27th, 2023, 61 days prior to this video interview, Jason Autry, through counsel of record, filed defendant's supplemental sentencing memorandum. So is he going to say something different 61 days before he recants in some type of matter that would impact his exposure to a sentencing length? Because I think that's what they're about to argue, and I don't think they realize why that argument falls flat. So In this supplemental sentencing memorandum, there were the following factual representations to U.S. District Judge Thomas Anderson concerning his federal sentence. So, Section 3 responds to upward departure or upward variance based upon criminal history. In arguing for an upward departure or variance, the government places great emphasis on Mr. Autry's guilty plea regarding his involvement with the Holly Bobo case. Mr. Autry is solemnly sorry and cannot express his regret deeply enough for his involvement in the case, and he fully accepts responsibility for his involvement in that case. While Mr. Autry cannot change the past, he wishes to assure the court he will never again be involved in any similar conduct in the future. While not intending to diminish in any manner whatsoever the seriousness of that offense, it is nevertheless respectfully requested that this court consider that Mr. Autry was sentenced for and has since fully served his custodial sentence in that manner. In doing so, Mr. Autry paid his debt to society for that crime, as determined by the Decatur County, Tennessee Circuit Court. While the government correctly states that he was originally charged with especially aggravated kidnapping and first-degree murder in that case, he pled guilty to facilitation of especially aggravated kidnapping and solicitation of first-degree murder. Mr. Autry testified as a witness for the state in that case and detailed his involvement before the judge and jury. In approving Mr. Autry's sentence in that case, the judge determined that the sentence imposed was appropriate, given Mr. Autry's involvement in the crime. Mr. Autry's testimony was clearly instrumental. Yeah, so your footnote here helps Doug's argument for the state in obtaining a conviction against the individuals who were found to have actually kidnapped, raped, and murdered Miss Bobo. In this case, that offense has been taken into account in the calculation of his guideline range, and Mr. Autry should not be given additional punishment for that offense. Jason Autry concludes his supplemental sentencing memorandum by reminding Judge Anderson that the court must weigh many factors in arriving at a fair and equitable sentence. While Mr. Autry admittedly has a very serious criminal history, it is the fact that, in connection with the most serious prior offense, his full cooperation with authorities resulted in bringing others to justice for their involvement in the offense. Oh my gosh, this is a long footnote. Moreover, on August 10th, 2023, Jason Autry, through counsel of record, filed defendant's objection to the pre-sentence investigative report, objecting to some of the factual statements contained in paragraph 55 of the pre-sentence report regarding his convictions in Hardin County for the docket 2017 CR 10, which I think is the Holly Bobo one. Defendant admits that he pled guilty and was sentenced as indicated, and that this offense give him 3 additional criminal history points. Defendant objects to the extent that factual statements in this paragraph could be interpreted to be inconsistent with his trial testimony in that matter. Emphasis added. Jason Autry's federal sentencing hearing is set to be heard on June 25th, 2024 at 1:30 p.m., and the representatives made by Jason Autry concerning his testimony in the Holly Bobo trial in Exhibits A and B speak for themselves. This is a long footnote, but they're emphasizing here that they're trying to use this federal sentencing statement to say, hey, before he recanted in December, 61 days earlier, he was reaffirming his plea and trial testimony in the Holly Bobo case. But yet within this footnote saying that same thing and trying to lean on that as an argument, they're like, well, actually, he did put this disclaimer in his plea that, some of it might be inconsistent, and he doesn't want to just concede that his trial testimony is different than what's written as an acknowledgement in his plea in the same manner. So I don't really get how this footnote is supposed to help them. It just kind of emphasizes that he has inconsistencies, but he wants to sign that ink. He wants the ink to dry on the paper to lock in a certain sentence. So, okay, and True Crime Fraud says this is why he can't testify in the post-conviction relief hearings. He's going to try to appeal his criminal history points in this PSI because he gets an upward departure anyway. I think it looks stupid to me that the state's writing this long footnote. It's not really helpful to him. It just underscores that within these documents, he's memorialized an inconsistency. Because he wanted to be able to sign the paper, sign the agreements. Oh, but, who knows? I've seen prosecutors argue stupider things. And we're back to arguments here. All right, so arguments for placing exhibits under seal. So in the alternative, the state's requesting that 1 and 2 are placed under seal, which, you know, keeps it outside of public record. Tennessee and federal law generally requires the public to have access to public records and documents. There's a strong presumption in favor of openness regarding court records. To seal the records, the court must find a compelling reason. However, per this court's own preliminary order, so that's what we saw, these things that we skipped over. Entered on, actually a different order. Entered on August 18th, 2023. The state of Tennessee was ordered to provide discovery to the petitioner in accordance with Tennessee Rules of Criminal Procedure 16 to the extent relevant to the grounds in the petition. The District Attorney General shall make all other disclosures required. And then since the entry of that order, the state of Tennessee worked diligently to address the exchange of discoverable materials with Petitioner Adams' counsel of record. They still didn't hand over the ATM video at this point in time. Subpoena gate has not yet happened. But okay, this is fun to read. They worked diligently. They allowed petitioner's counsel to use a private conference room in the DA's office and the week selected for the file review. Notwithstanding the foregoing, and in spite of the state of Tennessee's offer to make available the entire case file in its possession, Petitioner Adams' counsel of record advised that he is currently satisfied with the appellate technical record, 3, his ability to view the entire trial online, sort of, there are some clips cut out, and 3, Jennifer Thompson's case file, which should contain the voluminous discovery turned over to her during the discovery period prior to Petitioner Adams' trial, and which Petitioner Adams' counsel has in his possession. Well, maybe that's how they found the discrepancy. They looked at the case file and noticed that there's something that's not in the case file that Jennifer Thompson had. All right, they go into more case law about access to these records. Because Exhibit 1 and 2 are unsworn, they fail to meet the strict procedural requirements. All right, and then they request. They want Exhibits 1 and 2 stricken. If not, they want it under seal. And then these are just exhibits. Oh, they attach the sentencing memorandum. So Exhibit 1 is the defendant's supplemental sentencing memorandum. Oh. So they're arguing mitigating factors that he dealt with some child abuse. Anything relevant to... Oh, his mom's a retired correctional officer. Oh. He was prescribed a medication for schizoaffective disorder at the time of a recent evaluation in connection with his competency in this case. I don't know, could any of these things impact his ability to remember a traumatic thing, like helping to kill somebody? I don't know. I'm looking quickly for any mention here of his participation. Here we go. So this is what was in the footnote. This section 3. In arguing for the upward departure or variance, the government places great emphasis on Mr. Autry's guilty plea. Anything interesting here? Yeah, and that was really it. So they included really everything in that footnote that related to his participation in the Holly Bobo case. All right, so next thing, we'll get to the response to the motion to strike the exhibits. So this is going to be Doug and company responding. Also, shout out to Stacy Zivit, drop in 5 2 times in the chat. And we're good at math here, that means 10. So shout out to Stacy Zivit. You guys might want to check if you just turned green. You might have gotten a membership from Stacy Zivit. Make sure you're saying thank you. Right as we looked at 2 exhibits, too. Look at that. So shout out to Stacy Zivit. Let me get you in the banner. Thank you so much. That's super awesome. 10 gifted subs. Yeah. Andrea, I saw that. Brian Walsh is set to start tomorrow. I mean, is it jury selection? Is it going to be jury selection? And is that going to actually be streamed? Sometimes they'll go on the record and they'll be like, never mind, you can't stream this. Or no, did they seat a jury already? I'm so out of the loop on anything that's taken place in like the last 2-3 weeks. I've just been so invested in this case that everything else is a blur. But Andrea says, I really hope Brian Walsh pleads on the murder charge tomorrow before trial starts so I can watch the rest of this trial with y'all. So hope to have you. If not, I understand wanting to watch that live because, again, we're doing a retrospective. We're going back in time and watching this 2017 trial. So hope you can join us. But I know that Brian Walsh is I think it's interesting because he took a partial plea. He pled to some of the charges, and I don't think it's going to keep key things coming in at trial that look kind of sus. But I do think it was a strategy play, and it's kind of interesting to see how that's going to play out. So, all right, and jury was already seated, so straight to trial. There we go. Chat is on it. So yeah. Yeah, I don't know. I don't imagine him taking a plea to the first count, because what does he have to lose? Might as well just go at this point. But yeah. So I'll be watching that on rerun tomorrow evening. Louis, so the court is, so when someone's indigent, the attorney that's fighting, so Doug Bates, like if they need his own fees or fees for experts or whatever fees might be incurred, they file it with the court for reimbursement or to cover in advance. So he has been deemed indigent. The court, the state of Tennessee, is funding necessary things. Necessary things. And then we've got this response here. And I wonder if there's an exhibit or if they took 20 pages to respond. All right, so we have an exhibit here with the indictment. So that's interesting. Oh, it's case law. So he I see Rico mentioned here. He attached as an exhibit the case law. So let's see what Doug says in response to this motion to strike and motion to seal and counter motion for clarification on what information and documentation is subject to a protective order / confidentiality order. So let's see. Writ of quorum nobis was filed, which requires the appointed counsel to review the pro se petition, file an amended petition asserting other claims, which petitioner arguably has, or a written notice that no amended petition will be filed, interview relevant witnesses, that's bolded, including petitioner and prior counsel, and diligently investigate and present all reasonable claims. During the course of counsel's work, perhaps the most pressing issue of this case presented itself. Mr. Jason Autry discussed on camera with Dr. Katie Spirko that he fabricated his testimony out of desperation and belief he was going to be found guilty if this case went to trial, despite being innocent. Mr. Adams, through counsel, then utilized newly discovered recanted testimony to pursue this underlying writ of error quorum nobis. They're just going to call it the writ from here on forward, as allowed pursuant to this case law. Let's see. The hurdles before Mr. Adams to jump are significant. Admittedly, a review would be helpful. The law surrounding the writ has enjoyed robust appellate debate. A review would be helpful. The 2010 Tennessee Supreme Court case of Harris v. State, where the logic and reasoning of Justice Cook's and Justice Clark's concurring opinion was embraced years later in the Nunley v. State Supreme Court case that overruled in part the majority opinion in Harris. Oh, so I think we're gonna Oh, I think Doug's gonna challenge the state's interpretation of the holding in Nunley, or how it applies to the facts in this case. So the Nunley case stands for the proposition that the untimeliness of a writ is not an affirmative defense, but rather lies on the defendant must show on its face that it is timely or supports facts in its petition to equitably toll the statute of limitations. Embedded in the discussion about the statute of limitations is helpful analysis about the proceedings that begins with the petition. As Justice Cook outlined in Harris, there is one analysis for the face of the petition and another for the actual evidentiary hearing. Well, we know we made it to the evidentiary hearing stage. If a petition for a writ of error quorum nobis fails to show on its face either that it has been timely filed in accordance with Tennessee Code Section 27-7103, or specific facts showing why the petitioner is entitled to equitable tolling of the statute of limitations, the trial court is within its discretion to summarily dismiss it. And we know that didn't happen here. There's no requirement that trial courts hold an evidentiary hearing prior to dismissing a quorum nobis petition if the petition fails to meet necessary perquisites? Is that a word? For granting quorum nobis relief. If the averments in the petition are sufficient to warrant relief, the petition may be dismissed prior to any reason from the state or without a hearing. And we've got emphasis down here that trial court has no duty to try the issues raised in a quorum nobis petition unless the verified petition on its face shows sufficient grounds for the issuance of the writ and the necessity for a hearing thereon. Cook gave further guidance, stating that the petition must be verified under oath, and it is also advisable to file supporting affidavits at the same time the petition is filed. He wrote further, while there are certainly petitions for a writ of error quorum nobis that cannot be easily resolved on the face of the petition alone, trial courts need only conduct evidentiary hearings when they are essential. And then back to Doug arguing. More to the original point, though. Why did petitioner attach the recordings of both Mr. Autry and the additional new witness? So we're going to go back to the Harris case. In Harris, or Harris now with one R, 3 years after the trial, and you know what? At least we know this wasn't prepared by AI. In Harris, 3 years after the trial, someone named Bill, just Bill in quotes, sent the District Attorney General a letter confessing to the underlying crimes for which the defendant had been convicted. A handwriting expert was retained and identified the author in 2002. Justice Cook did not find the Bill letter was sufficient grounds for the writ for precise reasons the video of Mr. Autry's video recanting was needed to attach to his pleadings. First, the Bill letter was the basis of a prior post-conviction relief petition. Secondly, the concurring opinion found the letter was not admissible evidence, and its analysis revealed this Autry recording is proper. The key factor in Harris was that the letter was anonymous and thus not a statement against interest under Tennessee Rules of Evidence 804b3. Justice Cook stated State v. Kaiser, in which the late Justice Clark answered in a first impression case that an anonymous phone call that could be considered a statement against interest is not afforded the admission through the Rules of Evidence, because the crux of 804 is reliability, which is compromised by the anonymity of the declarant. The last and final reason Justice Cook in Harris found that the writ of error should not be afforded by the Bill letter, he stated the defendant's delay in filing a petition for writ of error was fatal. The delay was 13 years. And here we have the recanting interview in December of 2023, and this petition's already in 2024. So, however, at no time did Justice Cook state that the author of the Bill letter should have been presented in the form of an affidavit, and that made it fatal. In fact, it was never argued the letter not being an affidavit was fatal. So, where did that argument come from? Because the state cited Nunley, which relied on Harris. So, this is about a bunch of arguments about case law. The court's job is to determine if the petition and the supporting affidavits are sufficient to justify an evidentiary hearing, and the trial court should not determine the merits of the petition on the strength of the affidavits alone. So, there was an evidentiary hearing on this issue, and then with the motions in limine in June, and whatever responses, and maybe we'll get to those as we go down the docket, eventually the judge is going to say, hey, after hearing some more, I'm going to keep this under seal. Like, Jason's not coming in to testify, we're going to keep that under seal. Maybe one of the reasons for that is because of his exposure. He's planning to appeal. But yeah, but Doug got past this stage. Doug had this issue considered by the court, at least through some evidentiary stage. So whatever he argues here, the judge, at least in some part, found to be worthy of an evidentiary hearing. So then they go on. Let's see. At the evidentiary hearing, if a witness is deemed unavailable under Rule 804A, then at least Mr. Autry's testimony will pass muster under Rule 803B3, as he admits to some of the most offensive perjury imaginable, and could further be admissible under Rule 803-26 if Mr. Autry does testify. The other witness's video would be possibly admissible under Rule 803-1.2 and 25. That is the context the state seeks to strike such exhibits or seal them. At the risk of journalistically burying the lead, defendant does not object to the court clerk sealing these exhibits. However, nothing herein shall be construed as placing a protective order on them. The state is free to disclose these videos to whomever they wish, and likewise, the defendant should be. The arguments of the state bear significant analysis and exploration, which is why the defendant requests further clarification by this court as to whether there is any protective orders or confidentiality orders regarding the same. And they go through like line item by line item. This is a bit difficult because once we get past 3, I don't know, like when we have 4 and 5 just saying admitted, I don't know what that's in reference to specifically. Ooh, what do we have here? Let's see. Argument 11. Denied that recanted testimony is not newly discovered evidence. See, the petition outlines the first date Mr. Autry recanted his testimony to Dr. Spirko, and within 31 days the writ was filed, so timely. The state should be barred from asserting in the writ case that Mr. Autry recanting is not newly discovered unless it proffers evidence that it believed Mr. Autry was dishonest when it testified, a proposition defendant highly doubts the state will accept. So, yeah, you can't argue that it's not newly discovered unless you want to say that we should have known something similar to his recanting. It is admitted that we have another item here. It is admitted that Miss Carroll, so that's the woman who taken the kids to school, saw a weird guy in truck that was burly and seemed to be hiding something in the passenger area, that she later says is Terry Britt once she sees the news reports on TV. It is admitted that Miss Carroll's statement is not in the form of an affidavit. However, the defendant submits the affidavit of Dr. Spirko, and the verified petition properly authenticates the video and the statement of the witness. The video is also proper as it was work procured during Dr. Spirko's work and admissible under Rule 803-6 and Rule 703. Further, under Bland v. State, such video was appropriate. From the Bland case, on February 20th, 2020, the petitioner filed a petition for writ of error coram nobis, alleging newly discovered evidence. In support, he attached a summary of an October 28, 2016 police interview with Christopher Williams and an undated handwritten letter from Mr. Williams. The police interview was at Mr. Williams' request and addressed numerous other crimes, most of which the police were unable to verify. The coram nobis court held a hearing where 2 witnesses were called. So further from Bland, recanted testimony may be considered newly discovered evidence under certain circumstances. This court has concluded that a trial court should only grant a writ of error coram nobis upon the basis of newly discovered recanted testimony if 1. The trial court is reasonably well satisfied that the testimony given by the material witness was false and the new testimony is true. 2. The defendant was reasonably diligent in discovering the new evidence, or was surprised by the false testimony, or was unable to know of the falsity of the testimony until after the trial. And 3, the jury might have reached a different conclusion had the truth been told. So they're going to go and argue. And again, ultimately, the recording itself, the judge is not going to consider the Autry recording for this proceeding, the post-conviction proceeding, the decision he's going to have to make January or February. Yeah. Was it not newly discovered for you, state? So, yeah, that was a great little liner there. And they go in, they line item this. They go through some different arguments here. And again, this is all just to fight the sealing. The state's request to strike exhibits and, in the alternative, place things under seal. Next, on April 11th, so a few days after their response was filed, we have, so 11th of April, an amendment to the petition for writ of error coram nobis. So we're going to see additional things added to the petition. Shout out to Sheriff Chuck gifting 5. Let's get some W's in the chat. We could do some cowboy hats for you too if you guys want to drop some emojis. Big thank you. Make sure you're saying thank you if you got a gifted sub. Super, super nice. All right, we've got the banner up to date. And good to see you, by the way. I don't think I saw you earlier, so I think you're just getting here. So hope you're having a good day so far. We are, let's see, incorporation. They're incorporating everything in the original petition and just amending, adding this new whatever's below. So equitable tolling. The petitioner submits the following regarding equitable tolling. First, the recanting of Mr. Jason Autry occurred for the first time to anyone's knowledge, unless the state wants to say they knew earlier, including the petitioner on December 19th, 2023. These facts occurred well outside the normal 1-year statute of limitation. B, the petitioner had no knowledge that Mr. Autry was recanting completely his testimony. C, pursuant to the Exhibit 4, the statement of Ms. Jennifer Thompson, my attorney was diligent in trying to discuss with Mr. Autry directly his potential testimony. She was chastised for even recording Mr. Autry's attorneys when they talked with her. So we're showing that we tried to get this type of information when we could, but she was yelled at. She was chastised. Ms. Thompson stayed on my case, so this is in Zach's language, through the appeal from 2018 through his decision in 2022. And I think we're going to listen to the appellate arguments part of the stream. Yeah, like maybe we'll break up some of these April once we get done with April of 2024. We'll revisit how the appeal argument was argued. So she was on until the appeal decision in 2022, which was like an 81-page opinion from the appeals court that I skimmed through, and it seems to me like a recitation of the state's theory of the case, which, for what it's worth, that's not uncommon. That's not uncommon. That's not really that unusual to see an appellate decision just recite, storytell the state's version of events. She failed to file a permission to appeal. At no time did she advise me that Mr. Autry was recanting his testimony because he only did it in December of 2023. So this is new to me. Pursuant to the incorporated by reference pre-sentencing report of Jason Autry, as late as October of 2023, see Exhibit 1 to the state's motion to strike or seal, Mr. Autry was still maintaining. So remember how I said that footnote was stupid? That long footnote? They're referencing it here. They're saying as late as October of 2023, see Exhibit 1 to the state's motion to strike or seal. This is what they use in that footnote. Mr. Autry was still maintaining his perjured testimony was correct. Thus, his recanting, of course, took place well after the statute of limitations had otherwise run on this writ. What a dumb footnote that was. And if you missed it, Sheriff Chuck or anyone that just popped in here, there was like a half-page, single-space footnote that ran onto a second page from one of the state's motions that we looked at, the motion to strike or seal. So that was the time. Yeah, W is a win. Like W's in the chat, it's like appreciation, win, big wins. But yeah, it's like the opposite of L's. Oh, let's see. What did you do, FFS? Okay, I'll check Discord. If you accidentally hit someone, let me know. But I'm not seeing who it was. But yeah. Can you like put it in the chat like what the name was and I can go unhide them? Let's see. And it is really easy. It's kind of annoyingly easy. If you accidentally click a name, it's pretty easy to click the hide user on accident. So YouTube kind of sucks in that way. Okay, I'll unhide Stacy Zivit. Just I'll do it. Can it wait till I end the stream? Because I'll screw up if I start messing around in YouTube's backend right now. But I will. I will unhide Stacy Zivit. We've got, where were we? Pursuant to the incorporated by reference. Okay, that was the thing about the footnote. Second, strict application of the statute of limitations would effectively deny the petitioner/prisoner. Remind him that you're in custody. Hint at the habeas petition. A reasonable opportunity to present his claim on this new evidence. Specifically, the recanting occurred in 2023, and within 31 days, this writ was filed. G, there's been no strategic reason whatsoever for this delay. H, upon information and reasonable, well-founded belief, the state of Tennessee did not plea Mr. Autry out until well after my statute of limitations ran on this writ of error. Oh! For the reasons cited throughout, these cases are not non-meritorious. I submit I am actually innocent of the charges for which I'm convicted, and this new evidence proves it, or at least that I may have received a different result. Wherefore, premises considered, defendant prays upon this court to grant the writ. All of these things. Let us use subpoena power of the court. Let us call the prosecutors to the stand. All of that good stuff. Oh, we have an affidavit of Jennifer Lynn Thompson. So this was signed. Let's get a date of when she signed this in. April 9th, 2024. So my name is Jennifer Lynn Thompson, and I'm a licensed attorney in the state of Tennessee. My place of business is 810 Broadway. I'm an adult over the age of 18, and I'm not suffering from any disability that would prevent me from making this affidavit. The state is going to be like, you were fine when you wrote that affidavit, though, weren't you? You weren't suffering from anything then. I was appointed to represent Zachary Rye Adams in Mr. Adams' first-degree murder, kidnapping, and rape trial concerning the death of Holly Bobo. On January 21st, 2017, I received a call from attorney James Simmons. Mr. Simmons informed me that Jason Autry, a co-defendant in Mr. Adams' case, had reached an agreement to cooperate with the state of Tennessee against my client, Zachary Rye Adams. Mr. Simmons had spoken with Michael Skoll, attorney for Jason Autry. On January 27th, so same week, 2017, attorney Michael Scholl called me and we spoke for an hour by telephone. Mr. Scholl outlined the same basic facts that Jason Autry testified to at trial. Mr. Scholl did not include many details in the information that he provided to me. Mr. Scholl told me that Jason Autry would be testifying that he had seen Mr. Adams shoot Holly Bobo with a gun while under the I-40 bridge crossing the Tennessee River. Mr. Scholl told me that in exchange for his testimony, Jason Autry expected to receive no additional prison time beyond the federal sentence that he was already serving. Mr. Scholl explained that there were no law enforcement agents at the meeting, only attorneys for Mr. Autry and the state of Tennessee. The significance of having no outside witnesses was that Mr. Autry's 3-day interview with the prosecutors had been constructed such that there would be no discoverable reports produced by the state to the defense. By not including any law enforcement agents in the meeting, the entirety of Mr. Autry's interview, including any notes or recordings, would be considered the district attorney's work product and forever be off limits to me. One of the best ways to have impeached Mr. Autry's testimony at trial would have been to compare his trial testimony to his statement to prosecutors to show his inconsistencies, lies, or omissions. The jury could then use these discrepancies to determine that Mr. Autry was fabricating his version of events. Under typical conditions, there would have been a Tennessee Bureau of Investigation agent in the meeting to take notes and generate a report. Under typical conditions, the TBI would have made a recording of Jason Autry's statement. On January 27, 2017, during the telephone call, I asked Mr. Scholl if he would allow me to interview Mr. Autry. Mr. Scholl flat out refused to allow me to have any contact with Mr. Autry. Under the Tennessee Attorney Rules of Ethics, I was forbidden to speak directly to Jason Autry without permission from his attorney. By keeping me from Jason Autry, Mr. Scholl knew that it would be exceedingly difficult, if not almost impossible, for me to impeach his client, given the very limited evidence against Mr. Adams other than Jason Autry's testimony. The state did not provide me with any details regarding its 3-day meeting with Mr. Autry. There we go. There we go. Great affidavit there. Great affidavit. There's nothing that Zachary could have done to get a critical stage where Jason Autry is still expecting leniency, hoping to get leniency, but his sentence, any promises, nothing is set in stone until after he's going to testify, and you can't speak with him before he takes a stand. You hear state wants to depose people. We don't have time to interview witnesses. Oh, this is unfair. But here, the key witness, because it's a co-defendant hoping to get a plea, defense can't even speak to. Defense can't speak to. All right, back to April. All right, it says, State of Tennessee motion to hold amended petition for post-conviction relief in abeyance pending disposition of petitioner's writ of quorum nobis. And then State of Tennessee motion to issue subpoena to Katie Spirko and issue protective order. So we heard a little bit about that. And we also have a notice of appearance. And I think that rounds us out for the first quarter of 2024. What do we have in here? Anything interesting? All right, so on the 12th of April, the state intends to file a motion seeking the denial of the writ without an evidentiary hearing, which we know they lost this. When they submit it, they lose it. What are their arguments? They want the court to evaluate the claims for relief, presented and evaluated on separate tracks, with this court first addressing the writ of error quorum nobis. They want Petitioner Adams' amended petition for post-conviction relief to be held in abeyance pending disposition of the writ of error of quorum nobis, and any further general or specific relief to which the state of Tennessee may be entitled. So to me, this is, hey, we're pretty much asking you to summarily deny this and make it all moot. So don't start granting him partial relief, like letting him interview or letting him use subpoena power of the court without first deciding and hopefully just dismissing it all, saying, nope, the writ of error quorum nobis fails. And thus any of your other requests for relief that could help you in this petition and amend this petition, you don't even have the chance to do that. So this didn't work. This had to have been denied because everything continues to move on. We've got, oh my God, this is 56 pages. Okay, let's see if there's exhibits. This is the panic about Katie Spirko. Dr. Katie Spirko. Let's put some respect on her name. So we do have some exhibits. Motion to Michael L. Weinman to withdraw as counsel. When was this filed? February 7th, 2024. Well, let's start with this. So comes now Michael Weinman, court-appointed counsel for Jason Autry, moves this honorable court for an order allowing him to withdraw as counsel for the defendant in this matter. And in support states, counsel was appointed on April 21st, 2023. On January 31st, 2024, counsel for defendant became aware that the defendant's sworn statement was recently filed in an unrelated proceeding in Hardin County, Tennessee Circuit Court. Counsel met with defendant on February 6, 2024 to discuss the statement. During the meeting, counsel became aware of an ethical issue that makes his continued representation of the defendant in this case impossible, requiring counsel to withdraw because of his ethical obligations. In that meeting, counsel also learned of a potential unresolvable conflict of interest he now has with a client that counsel previously represented, which independently requires counsel to withdraw. Accordingly, counsel requests that he be allowed to withdraw. As evidenced by the certificate of consultation filed here within, counsel is referred with AUSA Beth Boswell, who has indicated that the government does not take a position on the relief requested. So, state is fine with him requesting. That's one of the exhibits. This looks like case law. All right, so a lot of this is just going to be this case law incorporated as Exhibit 2. And it was Woodward v. Woodward. Oh, we have text messages. Sweet. Yeah, let's look at these. Exhibit A. Jinkies. Well, that just looks like it says ACS. All right, this one looks like Katie Spirko at the top, December 7th, 4:59 p.m., texting with Katie. Thank you for speaking with me today. It's probably weird to say it was pleasant given the circumstances, but it was very nice to maybe meet you. And then something any files, something them. And then I can't send any files, but I can bring them with me and come meet you again and let you look through them if you like. I barged up on you yesterday and you were kind enough to speak with me. I figured it's the least I can do to let you know what's been compiled about Terry and you. And you definitely seem like an honest, intelligent, maybe person, so it'd be whatever to me to bring anything to you. Happened for Holly's sake, as well as to clear the names of all innocent parties who have been under a cloud of suspicion this time. I'm confident Zach is innocent and is something in prison for blank he didn't blank because of maybe work, the bad police work. The real irony to me is that your husband would probably be more likely than most people to hear him out. So many people just assume if someone is charged something of a blank, they probably something to the effect of they must be guilty. Keep getting blamed until the truth is uncovered. Happy New Year. Hope you were able to enjoy yourself over the holidays. This is now January 1st, and then the next thing is from February 4th. And that's the end. Maybe they write them out more in the motion. So let's see. The state of Tennessee's motion to issue subpoena to Katie Spirko and issue protective order. So Dana McClendon and Kinsley have been like holding the Trial and Error podcast down this whole time because Katie Spirko, can't pay attention, can't have involvement in this case, isn't supposed to be talking about it. But she did announce she's going to be working on a season 2 for Trial and Error that focuses on cases where victims don't get justice because the investigators, the prosecutors, they get tunnel visioned, they don't want to course correct even when they're wrong, and then they never actually get the right answer. So, Andrea says, I can't remember in the post-conviction hearings, did Bates ask Nichols about suborning perjury and coaching? There were questions to that effect, but I think as far as suborning perjury, the most direct question would be if she felt like that's what was happening with what Booth and Benjamin were doing with their interviews of Victor Dinsmore. So, but there were a couple little quips, I would say. Kathy Ferguson. If you missed the Kathy Ferguson, it was like 4 hours of testimony for these post-conviction hearings. There were some fiery clips from Doug about perjury and lying. Definitely a good one to watch if you missed it. Sheriff Chuck says, to be fair, the only time investigators get tunnel vision is when they are investigating. True enough. True enough. Oh. And Gwennon says to look at these documents, you have to have the VPN. Uh-oh. Yeah, I guess public access has its limitations. All right, so let's see. How long is their argument? Because these are the texts. So their argument's only 9 pages. Let's speed through this, and then I think the only remaining thing was a notice of appearance, right? And then it's the Honorable Dana McClendon III enters an appearance on behalf of Katie Spirko. There we go. There we go. So we're going to get through, we'll do this, and then we'll listen to the oral arguments from the appeal stage when it was still under Jennifer Thompson's wing. And that will be how we package this stream up. So here comes now the state of Tennessee by and through the undersigned and moves this honorable court to grant a protective order relative to any discovery materials made available to petitioner Adams' investigator Katie Spirko during the time petitioner's counsel employed her. As grounds, therefore, the state of Tennessee would aver. So this is super expansive. Super expansive. Because Katie comes off to me like she knows this discovery folder. And the state's saying, I want a protective order relative to anything made available to her. So she was given everything that Doug Bates was looking at. That's essentially a broad stroke protective order. So here, the state of Tennessee would aver that the state turned over 3 terabytes of pretrial discovery to attorneys James Simmons and Jennifer Thompson prior to petitioner Adams' trial in 2017. Attorneys James Simmons, we're going to call him Jim and Jen, were petitioner Adams' lead counsel during petitioner Adams' trial. Petitioner Adams' current counsel, Mr. Douglas Bates, advised the undersigned that he received a copy of Ms. Thompson's case file prior to filing the amended petition for post-conviction relief, and thus did not desire nor need to review the state's copy of the file. Due to the size and nature of the discovery, there are many instances where individuals' personal and confidential information was included. Attached to petitioner Adams' amended petition for post-conviction relief and writ of error quorum nobis is a sworn statement from investigator Katie Spirko, wherein she, through the allegations made therein, acknowledges her familiarity with the pretrial discovery. Such an exchange of information between counsel and an investigator retained by that counsel is not unusual nor improper. While petitioner Adams' counsel employed Katie Spirko, she attempted to interview Janet Britt. Miss Britt is the wife of Terry Britt, who was at one time a suspect in Holly Bobo's murder. Oh, so that's who she was texting? Aha, that's hilarious. On December 17th, 2023, Katie Spirko appeared at Miss Britt's home uninvited and without an appointment. So what? During this meeting, Katie Spirko offered to show Miss Britt what she described as new evidence. So that's the issue. See attached Exhibit 1 for affidavit of Janet Britt with messages attached. Now, I take issue with this, though, because just because you're trying to build rapport with someone doesn't mean that you're actually disclosing something that shouldn't be disclosed. So, on December 17th and 18th, 2023, Katie Spirko offered, through text messages to Miss Britt, to bring files and let you look through them if you'd like. And when Miss Britt did not respond affirmatively, asked her again, do you want me to come up again and bring the files I have? Because I figured it's the least I can do to let you know what's been compiled about Terry and you. See attached Exhibit 1 for affidavit of Janet Britt with messages attached. Katie Spirko further stated to Miss Britt, if Terry is innocent, then I'm working for him too. Zach will keep serving time, and Terry will keep getting blamed until the truth is uncovered. See attached Exhibit 1 for affidavit of Janet Britt with messages attached. See, this actually makes me more suspicious of Janet and Terry. That she was even willing to text at all. Maybe to see if you were serious. And then you got spooked when someone says they have files. You get spooked. So the above is not truthful, as Katie Spirko was very clearly not working on behalf of Terry. The state making misrepresentations. Let's read this again. Katie Spirko further stated to Miss Britt, "If Terry is innocent, then I'm working for him too." That's a phrase. That's like what's rising, what is it? Rising tide lifts all boats. What's good for the goose is good for the gander. If Terry's innocent, then I'm working for him too. Because the files would still be the same. The evidence would still be the same, and I'm working with the evidence. And then the state here argues, the above is not truthful, as Katie Spirko was very clearly not working on behalf of Terry Britt. To the contrary. There's an if. There's an if to begin this sentence. So this is just, I hate disingenuous arguments like this. There you go. D for disingenuous. GB's already thinking the same thing. Rude. Rude. Just crazy. A review of the post-conviction documents filed on behalf of Petitioner Adams shows that their strategy, at least in part, is to shift blame for Holly Bobo's murder to Terry Britt. A visit from Katie Spirko to Miss Britt in April 2024 further bears witness for whom Katie Spirko was working. Moreover, Terry Britt is not blamed for Holly Bobo's disappearance and subsequent murder. By you. 3 individuals, including Petitioner Adams, were found guilty at trial or through guilty pleas of these crimes. Petitioner Adams' counsel gave the undersigned permission to quote him saying, as of February 3rd, 2024, Katie Spirko stopped being considered an agent of mine. Yet on Sunday, February 4th, 2024, at 7:55 p.m., Katie Spirko once again texted Miss Britt and asked, "May I come out and speak with you again?" The text message does not mention that she is no longer employed by Petitioner Adams' counsel. See Exhibit 1 for affidavit of Janet Britt with text messages attached. Maybe they will call Katie in December. On Wednesday night, April 3rd, 2024, Investigator Spirko was dropped off at the Britt home by a large vehicle uninvited. Investigator Spirko advised Miss Britt that she was pro bono now. Katie Spirko further advised Miss Britt that Terry Britt will be charged for Holly Bobo's murder, and that Miss Britt can be arrested as an accomplice, and that Miss Britt needed an attorney that will look out for her best interests because my husband, Terry, would not. Oh! Okay, so this is from the text messages. This part is interesting. But why is this in quotes? So they're saying it's Katie advising Miss Britt, but then this quote reads as if it's written by Miss Britt. Needed an attorney that will look out for her best interest because my husband, Terry, would not. My husband, Terry, would not. So is there a text in there from Janet where Janet's saying, I need someone that will look out for me because Terry isn't? Because they're attributing it to Katie Spirko's advice, but that's not written as if it's advice from Katie Spirko, and I can't read the exhibit that's attached. So that's interesting. The large vehicle returned to pick Investigator Spirko up from Miss Britt's house. Investigator Spirko... Wait, was there more? For the affidavit? Did I miss it? Oh, okay. Affidavit of Janet Britt. I, Janet Britt, having personal knowledge of the facts contained in this affidavit and being competent to testify to them, hereby testify as follows. My name is Janet Britt, and I live in Decatur County, Tennessee. My husband is Terry Britt, and he's currently incarcerated. At one time during the investigation into the disappearance of Holly Bobo, my husband was a suspect. He was not charged with any crime associated with Holly Bobo's disappearance. We were aware that Terry was a suspect. Our home and property were both searched, and we provided the TBI with a receipt showing where Terry was at the time of Holly's disappearance. On December 17th, 2023, a person who introduced herself as Katie Spirko came to my house. We did not have an appointment. Mr. Spirko told me that she was working for the new attorney representing Zach Adams. She asked questions about the evidence taken from my home by the Tennessee Bureau of Investigation and the Federal Bureau of Investigation during the search warrant served on my home. Katie Spirko told me there was new evidence in the case. She wanted to show me the evidence and discuss it with me. I asked her if she would leave the new evidence with me to review, but she said she could not, but she wanted to come back and show it to me. Afterwards, Miss Spirko began texting me. On Sunday, December 17th and December 18th, 2023, this all seems like a rapport to get back to continue talking with you, without fulfillment of actually bringing files to Britt. On Sunday, December 17th and December 18th, 2023, I received several text messages from Katie Spirko and some follow-up messages. I provided her text messages to Brent Booth and Kathy Ferguson, special agents with the Tennessee Bureau of Investigation. Good to know you have a good line of rapport with Brent Booth and Kathy Ferguson. Kathy Ferguson, if you guys missed it, I think she's worse than Marissa Viverito. And Brent Booth, you guys have probably heard my thoughts on Brent Booth. The text messages I received and my responses to them are attached as Exhibit A to this affidavit. On Wednesday evening, April 3rd, 2024, Katie Spirko showed up at my house again. We did not have an appointment and I was not interested in speaking to her. She stayed at my house for approximately 10 to 15 minutes. During her visit on April 3rd, Katie Spirko told me that she was working pro bono and she knew that Zach Adams was innocent. We talked outside in my yard, and during that conversation, Katie Spirko told me that my husband, Terry Britt, will be charged for Holly Bobo's murder. Katie Spirko also told me that I can be arrested as an accomplice, but that she can help me get an attorney. She went on to tell me that I need to get an attorney that will look out for my best interest, because my husband, Terry, would not. Okay, so that's why we have this quote then. So I had just missed this affidavit when I was looking at the text. I didn't realize this preceded the text messages, but that makes sense. The large vehicle came back to my house and picked Katie up. I do not know if she recorded our conversations. If she did, it will reflect what's in this affidavit. All right, so that's why we're using the my language up here. Okay, so we were here. The large vehicle returns to pick up. Investigator Spirko, though previously acting as an agent of Petitioner's Counsel, made the statements regarding potential arrest and charge of the Britts in what can only be considered as an attempt to intimidate Miss Britt. Investigator Spirko's current role in continuing this investigation is unclear at best. I mean, I have a couple theories. She believes they have the wrong guy. Mr. Bates advised the undersigned that he is under the impression that Katie Spirko is now working for Petitioner Adams's family. There you go. And that would explain why she's doing it pro bono. So Katie Spirko may well have the right to continue her own personal investigation, as media groups, entertainment programs such as 2020, and podcasters do. However, she does not have the right to use discovery materials provided to Petitioner's Counsel to investigate under an umbrella of legitimacy. Furthermore, but I really think that was just rapport building. Because if you notice, there is no, she showed up with these files. She showed up with this paperwork. She was saying, can I come back over? Can I come back over? And then when she's there in person, well, I can't show you them, but maybe I can come back with them. It's the doorway to access. It's getting the foot in the door. And keeping the doorway to communication from Janet Britt open, because Janet Britt might be curious to know what you have on me or my husband, if anything. Furthermore, when a court is asked to impose a protective order, the court is required to give particular consideration to the privacy interests of third parties whose records are included in documents sought to be protected. As stated above, the 3 terabytes of discovery materials were turned over to trial counsel Jennifer Thompson, who, in turn, were apparently provided to Petitioner Adams' counsel, which is replete with third-party confidential and personal information. I mean, that stems from you, but okay. Lastly, the state has discovered several additionally concerning instances involving Katie Spirko. Specifically, portions of Katie Spirko's testimony in the matter of Woodward v. Woodward was stricken from the court record due to the trial court judge finding that her statements made during live testimony concerning the existence of contents of an audio recording were not correct. So we have a quote here. The court is concerned, however, when Dr. Spirko refers to Mr. Woodward yelling in a non-existent recording based on the statements of Ms. Woodward and her son, Wu? Oh, it's just initials, WEW. When there is nothing in her notes about Mr. Woodward having raised his voice or yelling. Therefore, the court is striking the description of the December 19th, 2021 incident from Dr. Spirko's report and testimony given by Dr. Spirko about that incident. First of all, I wish that courts would do this about law enforcement on the stand testifying to things that are not notated in their report. First off. Second, this striking a description of a recording is not the same I mean, it's not searchable, but they quote not correct, and that's not really... The state's arguing that it was found to not be correct, but then this little quote says, non-existent recording, and a detail wasn't also memorialized in a report, so he's striking the non-memorialized description. I don't know if not correct is quoted from somewhere else, but okay. We've got... The state is also concerned about the circumstances surrounding the creation of the Jason Autry video filmed by Dr. Katie Spirko on December 23rd, 2023, in a federal detention facility without the knowledge or consent of Jason Autry's then federal appointed attorney, Michael Weinman. The state is concerned that discovery materials are at risk of being disseminated and misused by non-parties to this litigation, which consequently may jeopardize all parties' interests in the administration of justice. So I understand the abundance of caution here. They're going to ask for this to, let's see, they want to subpoena Katie to find out if she continues to possess discovery materials or information gained as a result of reviewing those materials supplied to her by Bates, whether Katie Spirko is currently or has previously used discovery materials or information gained as a result of the reviewing of those materials since the professional relationship with Mr. Bates was severed on February 3rd, and whether Katie Spirko has shared any discovery materials or information gained as a result of reviewing those materials with media groups or entertainment programs such as 2020, whether Katie Spirko shared any discovery materials or information gained as a result of reviewing those materials with anyone other than counsel Bates and his staff, whether this court should enter a protective order under Tennessee Rules of Criminal Procedure 16D1 for all discovery materials possessed and or shared by Katie Spirko. So I understand abundance of caution here, but it would be disingenuous to suggest that she had, by what they presented with Janet Britt's affidavit, it'd be disingenuous to suggest that she had actually provided materials. Secondly, it's interesting that this number 3 for relief, we're worried about Katie Spirko sharing these materials with media groups or entertainment programs, but isn't it funny how those programs tend to often have juicy bits of information that they had to get from somewhere. And I don't know. Programs like 2020 go in and have interviews with people. So I'm still not really sure how Katie Spirko doing this interview, like, does the state file a motion anytime a news organization does an interview with a key witness or a co-defendant while they're in custody? Because they don't really get into an issue of like, well, they used McClendon's bar card, or maybe it wasn't McClendon, maybe it was the other attorney's bar card to get through the facility. They don't really raise that issue for the purpose of this motion. But yeah, so I don't know. Well, guys, that takes us through the April stuff. Next, it looks like as a teaser for what we'd get to in May, motion to dismiss petitioner's writ of quorum. So it's going to be them arguing, don't even hold an evidentiary hearing, just get rid of this thing. So we know they're going to lose that. More notice to strike exhibits from the petitioners. Let's see. An order striking exhibits, so the judge strikes something. State of Tennessee's reply to Petitioner Adams' response to the state. So maybe next time we do one of these, we'll go through like May and June. Maybe this July one. Wait, these two are marked 2025. Is it actually 2025? Okay, this is typed incorrectly. The first one I clicked says it was filed May 24th. And this was due in 2024. So this must be just a typo. These look like they're actually from 2024. So we'll keep going through. We'll do like chopping blocks of this, all the docket stuff. Do you guys want to listen to the oral arguments from Jennifer Thompson for the appeal? This would have been back in 2020. I think it's like an hour and change. So it's separate from these proceedings. Or do you want to end it here, get time to catch up if you guys are behind on other stuff, and reserve that for another day? Totally your call, you guys. Yeah, Stream Graper says I'm catching up double time. K Rig says if everything about the investigation and conviction was above board, why are they so scared? And it's interesting, right? You know, usually the scramble to keep things out of the record comes from, it goes both ways, but it usually seems like the defense is fighting to keep things out of the record. So, yep, Gwen and Garnett with the recall. 2020 had stuff from the Koberger case that wasn't public. It's interesting that that's okay. Interesting that that's okay. And I'm all for public access. I think it should be a high burden. But I have serious concerns that, you know, since prosecutors are the ones that are more likely to have access to the information in the first place, they have more opportunity to be the ones that do things with information that they shouldn't be doing. And I feel like courts overlook that or make it, oh, it was an accident. So, yeah. You get a slap on the wrist after the fact. But if it was a defendant that did it, oh, it's the worst thing ever. And then I have a sure. I think that's a yes either way, maybe. Tatum says I'm never catching up. But I have a strong sense that they didn't have enough evidence to convict Zach. Yeah, I think that's a reasonable place to land. I think it's all going to come down to the ATM and what Marshall Walker wants to be able to present, if he can present such a thing at a new trial. And I mean, again, like, that's assuming Jason Autry can go tell his exact same story. If they don't have Jason Autry, are they going to try to put Dylan Adams up there? It's just, I mean, there's like talk about parallel universe, right? If we could run simulations on how these things could go if there was a new trial, but like this trial, the one thing was kept out in this trial, how would it go? If this one, a different piece was kept out, but this thing could come in, how would it go? If it was a different jury, if it was a different defendant at the witness table, at the defense table on trial, like the simulations that I wish I could run with the hypotheticals are crazy. We've got, the oral arguments are painful. That's kind of why I don't want to let it run. I don't know if I want to listen to it today, to be honest. I'll show you why.
In his statement, denied that they discussed that day when Zach and Shane.
It's like tinny. There's like a grating, bubbly sound to it. I say let's reserve this one. Let's keep this one a short day. This will be on the chopping block, you guys. We'll get it in here eventually. And what I want to do, there was an 81-page decision for this appellate thing. And like I said on reading, and I'll link it in the chat, and it's like single space, like it's a lot. And it's really just going over that there was sufficiency of the evidence, and we disagree that there was ineffective assistance of counsel. Actually, I don't know if that was raised, but it's a lot. It's going to recite everything that the state presented and say that it was enough. Even if there was one small error, there was still enough on the record. Let's see. The defendant has not demonstrated that multiple errors occurred during the trial. Without multiple instances of trial error to accumulate, the cumulative error doctrine does not apply. Thus, cumulative error relief is not appropriate. So right here, I mean, I think we have a different court hearing this. This is back at the trial court, coincidentally with a different judge because the previous judge retired. And then we have a much better, a well-formulated argument in this petition that we looked at today. I think we might actually get a different outcome than what we had at the appeals court. So I think we're going to reserve, we're going to listen to that mess another day. But as we go through certain issues, like there's a section here that just talks about Autry. Like maybe we can just loop in different chunks of this long thing. Rebecca Earp, which we missed, but you know, maybe we can loop these things in where appropriate, because 81 is a lot of stuff to read. So we've got, let's see, tomorrow, day 7. It'll be the rest of day 7, maybe some of day 8. Probably be able to get through day 8 and 9, and maybe wrap up Tuesday. Maybe we'll carry into Wednesday, you guys, as far as calendar. On the 5th, which is going to be Friday, we do have hearings. So if for whatever reason it takes us until Thursday to get through the trial stuff, we still have stuff left over. Friday, there's supposed to be motion in like the Courtney Clinton hearings and a bunch of other stuff. So Friday we'll be streaming different topics. But other than that, once we're done with the 2017 trial, we'll start digging back into this post-conviction stuff and stuff happening outside of court. So, also big thank you here. FFS has been a member for 15 months, holy moly. This is thank you for everyone who joined us today. Super, super thank you for spending your Sunday here, not just hanging out with us, but also taking interest in this hot mess of a case. And yeah, so true crime fraud at my weird browser history, I had to click again to unfilter. So when I opened something to view all history, it was undoing the filter to show all history and went back to showing me recently closed, like the most recent tab URL. So yeah, a hot mess, but really annoying. The oral argument. And I think James Phipps shared it in the general chat in the Discord server as well. If you want a quick link, it is in the chat, but it was also recently shared in the Discord. So there's the Discord link if you guys aren't in it already. I think you're in there already, True Crime Fraud it. But it was a recent post there in the regular chat. And Tatum, our 1 month anniversary. Heck yeah. We got to do something to celebrate. So big thank you for being a member, both to you and for FFS. FFS is going to brag. He's like, I've got 15. So there we go, you guys. We're going to wrap this one up. Yeah, I'm losing my voice today. I'm losing my voice. I need to go have some soup or something. But yeah, we'll be back with trial watching tomorrow where I don't talk all that much. So it doesn't matter if I'm losing my voice. We'll be on schedule for that. Maybe a small chance of doing a watch party over in Discord. I've been wanting to watch Thin Blue Line, a suggestion from James. And it's available on YouTube to watch. So I forget what it's called, but YouTube has something where like movies and TV, it's free to watch for a certain period of time. So definitely think that'll be fun for us all to check out. It seems relevant to the things we talk about on this channel, and a bit more casual than doing a stream about it. And then Sheriff Chuck with 5 more as we close it out. It's like party favors, goodie bags. So Sheriff Chuck, thank you so much. If you just got gifted a membership, you guys know the drill. Big thank you here. Let me update the count here just to get it right. Oh, that's 50 new members today, you guys. We're growing the gang again. We are going to be a huge force. You can't combat us. You can't fight with us. Thank you so much for all the gifted subs today, you guys. Curious Lay says, I studied that film at university, so I'm excited. I've heard it referenced, like people have discussed it, but I've never actually watched it. So pretty excited to check that out. And Jay Money says 50 with the strong arm. So there we go. You guys all have a great rest of your weekend. See you tomorrow if you want to come hang out. If not, enjoy if you're going to watch like Brian Walsh, whatever else is going on. Feel free to bring some updates. I'll be on replay crew for that since we'll be streaming live. But other than that, thank you so much to everybody. Yeah, we'll call it the Justice Force. Everybody take care.